So you're a common law spouse in Jamaica, but to what extent does the law protect you? Does being unmarried reduce your chances of benefiting from your partner's assets? What if it's a house and your partner dies? Are you entitled to it, or would his family automatically have the upper hand? In this week's edition of Query This, Chantae McNeil explores the rights of common law spouses in Jamaica.
You've been living with your child's father for almost 8 years. Together, you built a life and a home. You have a child, but the worst happens. He dies in a sudden accident. After the tears are shed and the earth settles over his grave, his mother tells you you aren't deserving of his son's assets and kicks you out of the house you both once called home. Is this fair? Is it legal? Should a common law spouse have the same rights to property as the legally married wife? Here are some of your views.
That could never be fair. I'm supposed to get what me deserve and then the family can go with the rest. It could never right. That will never right. Not under my regime.
5 years, the law says right now, after 5 years, we're legally married, with or without a license. So she have a right to stay.
And if me pass off and left asset, and not for family alone, I feel woman me and her in a relationship for. And if any go on over the asset, then me don't have to get up and box down over box down. Straight.
Well, if she deal with things right, she can stay. If she not deal with things right, she have to leave. Family might take over.
Interestingly enough, under Jamaican law, a common law spouse can have rights to the home they shared, rights that mirror those of a legally married partner. Attorney at law Michelle Thomas breaks down what the Property Rights of Spouses Act, known as PROSA, say when handling such a scenario.
Once it is that a single woman and a single man has been cohabitating for 5 or more years, they will be considered as common law spouse. They're in a common law relationship, and this gives them similar rights as if they were actually married. So no other family member can just get up if it is that the common law spouse, one of them die, and just put them out of the house. Once it is considered family home, then that surviving spouse has an interest in the property.
So, if your partner dies, Thomas explains that the first legal step is to apply to be declared as a spouse. That, she says, opens the door to your rightful recourse.
Serve it on that individual who has put her out, because that person, I would presume, would be an interested party. Maybe that person might be a child of the deceased spouse or a close relative to the spouse itself. In that regard, they will have to give them notice that they're making the application and thereafter apply for an interest. So they have their recourses. All they have to do is to get an attorney, retain an attorney who specializes in the area of family law, civil litigation, so that they can get some assistance.
Married or not, once you live together for 5 years or more, you share equal footing when it comes to property rights. So know your rights and use them. And that's how we close the curtains on this week's edition of Query This. If you have legal concerns and not sure where to turn, email me at cmcneil@cvmtv.com with your questions. I'll help you find the people and the answers you need. Until next time, I'm Chantae McNeil.